The pen I had has disappeared. It's in my pocket. It's a bit like up here. So good afternoon, everyone, and welcome to reconvening of the hearing in relation to the natural features and landscape chapter, and also natural character draft that has been put out. So this afternoon we're hearing from Montwood Station, and Coral McLeod is present. So we have read through the submissions, Coral, we've read through all the material that's been given to us. So we're in your hands in terms of what you would like to say.
Right, yeah, thank you for that. So basically what I've got to present here today is just kind of my thoughts, for want of a better word, so I'll just head on into it if you're all happy with that. So yeah, thank you for the opportunity to talk today. While I welcome this opportunity, I would have welcomed the opportunity to talk with you all prior to the proposed district plan being drafted. This could have saved a lot of time and money for all concerned. I'm here not as an expert, just as a landowner within the proposed ONL whose family have owned this land for over 120 years. I'm a fourth generation McLeod to be guardian of this land, and I hope that many more future generations get to have this opportunity. I'd like to thank Mishka and Mike for taking the time to have discussions with me around the proposed district plan NFL rules. The consensus reached on the rule section is a step in the right direction, and I'm pleased to see the 42A report reflects changes because of these discussions held. While it's not the perfect result, it is a lot better than it was as proposed in the proposed district plan initially. It is good to note NFL Rule 5 states that fencing within the ONL area is allowed. This is huge for us as it allows some sort of normal farming activity to happen within the ONL, something that the proposed district plan doesn't allow. I hope you see the common sense in this change. Am I correct in thinking that you still propose to have rules around earthworks in relation to fencing in this chapter? Okay, so that's the rules regarding Rule 1 and 2, is that right?
It's Rule 3 in the NFL chapter.
Rule 3?
Yeah.
Okay, so it stands alone or the earthworks overlaps over it?
So that's been a reoccurring theme today. So the panel have a couple of recommendations from the Earthworks Section 42 author, and I'm not sure where the panel will be landing. At the moment, the recommendation from the Earthworks Section 42 author is that the Earthworks chapter applies as well as the NFL chapter. However, when I drafted this, that wasn't the case. So I've only been considering things from a landscape perspective, and I do still stand by NFL Rule 3, which is what had been discussed with you previously, that's appropriate for dealing with landscape effects. But the Earthworks chapter does consider other things like stability, so it's with the panel at the moment, and there's an upcoming hearing to discuss that fully.
Okay, so decision pending basically. Right, okay, so please note that the current plan does not make any limitations on earthworks relating to fencing or tracks. This is a common sense approach as it realises the area is farmed and these are necessary requirements for day-to-day farming along with health and safety aspects. Any limitations that stop us from adding new fences or replacing existing fences is something I would ask you to discourage. These normal activities along with others need to happen regardless of whether a farm is in an ONL or anywhere else. As a matter of interest, have any of you on the hearing panel been on Montwood, specifically the proposed ONL area of the farm? If so, what brought you there? Anyone?
Keep going and we'll come back.
Come back to that? Okay. So as said in my submission, the big thing for us is that this area is a farming area, a large portion of our entire farm, and we still need to be able to farm it. Our livelihood depends on that. The farm is leased out currently, so while I am not involved in the day-to-day running, I do have some involvement. The proposed rules in the ONL limit us to being able to easily, if at all, venture into diversification as some sheep and beef farmers are doing. So farming as we know it is potentially all we have left. I did think we may have still had a possibility for an agri-tourism side hustle, but the proposed district plan states that non-farming buildings are to be a maximum of 2 metres high and no more than 5 square metres. So I cannot see an agri-tourism accommodation unit fitting those criteria. So just to give you a bit of background on our property and the direction we are heading, the simple vision we have for Wantwood is to return the rough gorse areas to pasture. Having the land in pasture rather than gorse surely must be ideal from anybody's perspective. It's a hard road, but one we're prepared to tackle, and one that our neighbours at Stony Creek have tackled with great results over the years since they have owned the station. That's our vision, and I'd appreciate your help in making this happen, by not placing unrealistic expectations on us to continue to farm. The cost of having to apply for a resource consent to do normal farming activities, as the notified proposed district plan suggests, would be restrictive by way of time and money, which in my view, and I'm sure the view of many others within the Gore district, could be better spent elsewhere. If we're constantly spending time and money on resource consents, then that is time and money that we don't have to spend on pest control, increasing biodiversity, or getting on with other normal farming activities. Farming within the ONL should not be seen as a negative. The experts even say that farming contributes to its outstanding landscape, and Gore is unique in that most ONLs aren't farms. Something to think about. In the 32A report of the proposed district plan, it said that the current provisions that manage the Gore district's identified landscapes appear to have effectively managed development within the Hokonui Hills. My question for you is why the proposed district plan looks to increase the rules dramatically when there has been no cause for concern. Once again, this is a farming landscape as well, not just an outstanding landscape. We need to be able to continue to farm it. What do you think will happen if we're unable to farm our land? I'd like to make a comment on Mike Moore's report, Appendix C. Mike Moore assessed the ONL area on Wantwood and subsequently made changes to the boundary following his visit, namely removing a small lower portion of the farm at the west end along with the neighbouring properties in this area. Thank you for that. There was a suggestion from Southland District Council that you could create a VAL based on the assessment done back in 2019 to create the document called the Murihiku Southland Regional Landscape Study. This is a document that SDC asked to be prepared for a different purpose and has no bearing on the Gore District Council proposed district plan. Please refer to the disclaimer at the front of the Murihiku Southland Landscape Study. I ask that you follow the directions from your planners and landscape architect to not have a visual amenity landscape area added. There are more than enough classifications already, we don't need another. In Appendix 5, you look to add that pest plants and animal infestation pose a threat to the landscape values. I'd agree with that. Please note that having hills, native bush and living next door to a dock reserve can make it very hard to control pest animal species. As you get to the, let's grab a drink. As you get to the stage of deciding what will be in the proposed district plan, I ask that you carefully consider what rules you impose on this area. I know that times change and we all have rules to deal with. However, imposing rules that make it very difficult to do day-to-day farming may not have the desired outcome you are trying to achieve here. I'm aware of the landscape and biodiversity on our property. This awareness won't change regardless of whether you put harsh rules in place or not. Tough rules will just make the processes a lot harder, and some things we want to achieve to improve our property may not be able to be done, which in the end will affect the ONL more. I know you're obliged to consider rules from central government. That's where your direction comes from. But you also have the ability as to how you interpret and implement any possible rule changes. With the likelihood of changes happening soon to the RMA, which could very well be in the favour of us landowners, I ask that you consider this aspect when making your final decisions, as we will have these rules for many years to come. One last thing I'd like to say is I'm lucky enough to have an old black and white photo of the hills of Wantwood at home. The landscape is just as outstanding then, which was dated 1950, as it is now. So back then, its only label, as far as I'm aware, was the Hokanui Hills, something that was valued by us then and something that continues to be valued by us now.
Thank you, Coral.
That's
And
me.
thank you for the effort that you've gone to of putting it in writing. That's tremendous and of some help in terms of what we're looking at later. We've got a plan up on the board, and just wondering, oh, there's a second one there underneath now. Just wondering whether you can highlight where Wantwood Station is. Yeah, please. What's the one underneath? Is that your boundary?
I believe is what Wantwood Station prints up, so you can either confirm or deny that one on the blue outline.
So the blue outline is what you're saying is Wantwood?
If that's correct.
Yep, that looks about right. Yes, that's correct.
All right,
Well
so when we compare it to the landscape area, the right-hand one, yeah, the two on above,
Yes.
how much of the property is included in it?
In the land, in the ONL.
Yes,
Okay, so
You can draw on it.
yeah, you can
Again?
use that on it, yeah.
this will be just super
Yep,
rough.
yep.
Guys.
And if you bound Stony Creek, the right-hand one shows their property boundary.
That,
Yeah,
that one?
yeah.
Okay. Okay, so just to clarify, you're wanting me to put the overlay basically of the whole farm outside?
Yeah,
of the-
except do it on the right-hand one, so it matches.
Do that
yeah.
on here as well,
No, just do it on the right-hand one.
but I'm doing on that,
Yeah,
right, okay. It's a wee bit blurry. Sorry, it's a wee bit hard to see.
use the thick bit. I'll show up a bit better. Is it coming through okay? Yeah, that's better.
So it looks like most of the property there.
Yeah. Yeah.
Right, so the ONL boundary is pretty much the property boundary at X.
Okay, thank you. That's very
Pretty
helpful.
much, yeah,
Yeah.
so that white bit just kind of
Yeah.
There's only a little, so there's just a wee bit that's outside of it.
How much did you say was in, if Wantwood was in an ONL?
I think from memory it was about 65%.
Okay,
Yeah,
so similar to
That's,
Stony
that's
Creek.
not subject to Mike's recommendation,
Yeah,
changing those slight changes, so I guess we're still looking
All
at
right.
60,
Yeah.
maybe.
Okay.
Thank you.
You mentioned about being on the site, and in 2 weeks' time we've got the hearing that's dealing with ecological values, and there may be or may not be may be some benefit in us actually coming to the site. Is that something that you'd be comfortable with if it's set up and following whatever rules are needed?
Yep. Are you talking in between times or after the next hearing?
After the next hearing, as part, once we've got all the information together, we need to have a bit of a chat in terms of do we actually want to go out on the site and look at it in a bit more detail, or do we have sufficient information without needing to do that?
Yeah, I'm fine with a site visit if that's what's required.
Okay.
Yep.
All right, so I'll throw it open to panel members if there's any questions of Coral. Cliff? No? Yeah.
I was just going to comment, actually, Coral, that I have been on Wantwood, and it was when your Auntie Mary was in the house at the time.
My grandmother.
Your grandmother,
Yep.
yes,
Ah,
was in the
It's
house.
a wee while
And
ago,
that's
Glenys.
a long time ago, but she took us to see quite a bit of the farm, and
Oh, cool.
yeah,
Yeah.
that was a long time ago,
Yeah.
and
Oh.
through the house.
Yeah. Well, if we do a site visit, it would be nice to see your perspective on then versus now. Yeah, true. Thank you.
I've got a question. I think you've raised something quite important when you were talking to us around the potential limitations on agritourism and what you had in mind. So I'd be really interested to understand, because you've described one of the limitations, which is building size. But before we get to that, if you could just talk us through a little bit more about what you had in mind, so we can then think about the provisions and how they affect that aspiration.
Okay. It was more just an idea, as in this is kind of looking at with these changes that are being proposed. It was just sort of looking as in, do we have options to do other stuff? So, I mean, if we were to look, like, as much as you guys like class and we all do, the landscape is outstanding, like the views that we actually get from the property looking elsewhere would actually be quite perfect for something like that. But then, like, I guess you are limited by that size, because you'd probably, I don't know, maybe look for something that was a bit bigger if you were doing like the accommodation type thing, which could be up to, I don't know, 60 square metres or something like that, which based on the plan we would have to apply for resource consent to do that, and obviously site and everything comes into it. But yeah, that's just where I was thinking with that. I do not have final figures or have done major stuff on that. That's just a thought.
And when you're thinking like that, you know how we've got the two different areas. We've got the low sensitivity area and then the high sensitivity. Were you imagining making use of the low sensitivity areas for these other kind of things, maybe?
As in like the agritourism side?
Yeah.
Yes, probably. There's certain aspects of the lower sensitivity that you may get a spot that still has tremendous views. Obviously, the higher up, I guess, you go, when potentially that's the higher sensitivity area, there's also the options for more spectacular views from that side of it. But yeah, it could be worked within the lower sensitivity area if need be.
How do workers on the farm move around? You know, what are your trails like? Are people using horses, motorbikes, or what?
Yeah, predominantly four-wheelers, side-by-sides, and four-wheel drive trucks. So, as our main modes of transport on farm.
And aspirations in terms of future management, do you see things remaining as they are, or what's your vision for 10 years out in terms of the way the property's being used?
So what are you meaning by that exactly?
Well, I assume there's some grazing that takes place at present. Are you looking at increasing the number of paddocks,
Yep, gotcha.
more intensive use, changing to something else, or?
Yep. Well, we're kind of in the, I guess, for want of a better word, a development stage on farm. There's been historically lots, those that know the farm or have seen it over the years will know that there's been like major amounts of gorse. So we have cleared some of that gorse, and the process of that is getting it from gorse into grass, basically. So part of that, we have done some subdivision. We would also possibly require to do some more subdivision of blocks, just so that they're much more manageable from a stock perspective.
And as a consequence, then more fencing.
Yes, yeah. And we do have a bit of older stuff, old fences that need replaced as well over time.
No, just thank you for for having your voice today.
That's fine.
Yeah.
Thanks for the opportunity of listening, and
Yeah, and thank you for coming in. Thank you for in writing, but Cliff's got a question.
Question for Mike and Mishka. Stony Creek, Wantwood, same issues, same outstanding national landscape category.
Yes, and with both the lower sensitivity and the high sensitivity included.
Yep, so they're very, very similar.
Yes.
Okay, that's fine. Thank you very much.
All right, Colt, thank you very much. Appreciate you coming in and helpful.
no problem.
And we might see you again in 2 weeks' time.
Yeah, you will.
Excellent, thank you. Cheers.
Thank you. Bye.
Given that we have now finished hearing from those people that are going to appear today, we'll return to our advisors and some more in-depth questioning in terms of the issues. And I guess we're going to start at that end of the table and work along.
I don't know, you sure you don't want to come the other way? 'Cause I'm always the one with the most questions. Yeah. Okay, I'll
Just to interject, I have done a little bit more thinking about some of Maria's infrastructure policy 3 questions. I can start with that if you like, unless you have, yeah. Okay, so I take Maria's point that the operational and functional need comes from national direction that doesn't necessarily apply to all infrastructure generally. So I've sort of worked on tweaking things a little bit. Whether or not people and submitters will enjoy that, I don't know. It's up to them. So I'd like them to have the opportunity to give some feedback. But I thought about just adding in something similar to ring fence that operational and functional need to critical infrastructure. So I've sort of workshopped the idea of having it say, avoid the placement, policy 3, NFL policy 3. And that would need to carry on to the natural character chapter, whatever, just for consistency, whatever you decide with natural features and landscapes, I think should be carried over to natural character. But avoid the placement of infrastructure within identified ONFLs, unless, and here's the new bit, and in regards to critical infrastructure, comma, having regard to the operational needs or functional needs of the activity. And then stepping down, there's no change there to there is no reasonable alternative for the location. I think that line in particular, and Stony Creek might want to weigh in at some point, is useful for farm infrastructure, because in the case of Stony Creek or Wantwood, there's no reasonable alternative other than the ONL, because that's where their farm is. So I think that still covers that aspect, because I'm not trying to exclude them from thinking about things practically. And adverse effects on landscape values can be avoided or appropriately mitigated, and then still stepping down to that that change in green that I recommended.
The word unless, is that coming out as your recommendation? I think you use a slightly different word in the first line.
I think I just added an "and" in regards to critical, but the grammar and the details I'm happy to refine further.
Yeah.
So
So the function and operational need you only want to apply to critical infrastructure, is the outcome you want to achieve.
Just to reflect Maria's point about national direction, and you don't want to over apply that to where national direction doesn't necessarily apply. But I do think practical considerations need to be undertaken in regards to farm infrastructure. So in my view, there is no reasonable alternative for the location. Probably covers that in this instance, but Stony Creek and Wantwood might want to. I just think they should have the opportunity to respond to that, and Brett's probably not wanting to do it on the fly right now.
Maria, have you got anything else with regard to policy 3?
Not questions, just I'm absorbing the evidence that we've got and thinking that that's a helpful offering from you. I think it might need a little more jigging. Two things that came through the Transpower conversation. Ms McLeod was talking about that discomfort between an avoid signal with caveats, and just kind of how we navigate that. But she also alerted us to this. She had some issues with the use of the placement of, because she was thinking that what we're trying to avoid is the effects, or avoid inappropriate. She was talking about avoiding the adverse effects as opposed to avoiding the infrastructure. And so that was, I think, quite an interesting thing for us to think about as well. Yeah.
Can I comment? My take of functional and operational needs is slightly different to Ms McLeod's, and that is particularly with reference to the Supreme Court decision, which gives that functional operational need a different relationship to the avoid policies. So I felt that where she had significant concerns they couldn't sit together, if the policy reads in a practical manner to provide a direction, then I possibly thought that she was being a little bit too black and white about it.
Right.
That would be my submission.
So, in relation then to the national grid, have you got any feedback you want to offer in terms of a standalone policy versus a policy that is more generic to other infrastructure versus what you have?
I think the addition of clause 3 in that policy stops it being too generic. However, I'm relaxed about the introduction of that being introduced as a new policy. It will just need a few repeated words, but that's not the end of the world. I guess within my supplementary evidence, I wasn't so keen on the changes to policy 1 because it was a really long walk for a short drink of water for a very specific activity, which is why I wanted to bundle it into the infrastructure policy, which is how I see policy 3. So I don't necessarily think we need another infrastructure policy. However, as long as the same result is achieved, I don't mind.
Bit of clarity for me, thank you. So, critical infrastructure for a practical and operational need. How does that cover, or does it not cover, farm infrastructure? Because I see the two things as quite different.
I agree, it is different. So that's why I think it's important to have that policy referring to infrastructure more generally rather than critical infrastructure. And then it only narrows down in regards to operational needs or functional needs for critical infrastructure, because that's where the national direction is providing that requirement. But I agree, farm infrastructure does need to be provided for. And so I would prefer it still included under the banner of infrastructure within this policy. And to me, clause 1 of that policy, there is no reasonable alternative for the location. I believe that's sufficient to provide for farm infrastructure in these areas. However, their submitters might have a different view.
You feel you don't have to use the term infrastructure, just infrastructure, as it delineated from critical infrastructure. Okay.
I
So
mean, we-
infrastructure.
Yeah, given infrastructure is defined in the plan and it doesn't include farm infrastructure, how do we get around it?
It does?
Didn't you have the definition of it?
Yeah.
Certainly includes irrigation.
Sorry, I'll bring up the definition.
The water supply distribution system is E, including a system for irrigation,
Yeah.
not for watering of stock.
Irrigation is a consented activity, though, through the regional council, so you'd have no chance out there.
No, that's including, so our water supply.
A water supply distribution system, including a system for irrigation, to me, that's not an exclusive list.
Right,
And I
okay.
would consider that, yeah, my intent is that farm infrastructure is included in this, and that would be my reading of the infrastructure. Definitely not wanting to exclude that.
Yeah,
Yeah.
okay. So, because I see it as an important point, we need to be satisfied as provided for. And from a pragmatic way. So I'm accepting of what you're saying, that clause E enables then the distribution system of stock water around the farm. Thank you.
Once again, the use of farm infrastructure is that district-wide as opposed to, for example, within a precinct. Right, so that's what, okay. But, okay. If one had a mind to consider a precinct, you could narrow it down, couldn't you? Look, it's a rhetorical question, you don't need to answer, I think.
I was looking at paragraph 1 of the overview. So to begin with, I was looking at your statement, and you've answered lots of what I had from your statement of evidence before we get to the Section 42A report. But when I was looking at your paragraph 102 of your statement, and then I had a look at para 1 of the overview, I wondered if we needed to change the text in here in light of the new natural character chapter. Because at the moment it's saying addressed within the provisions relating to stream setbacks included within the zones. Do we need to just add something here around the function of the new natural character chapter?
Yeah, I don't think that would hurt. I think it's still appropriate to refer to it in here. And yeah, I have no issue with referring people to the natural character chapter.
Okay, so now if I actually get away from your statement into your Section 42A report. Oh no, I was looking, hang on, just.
Just looking that up. The paragraph 112 of your evidence, there have been some talkies with Southern District Council with regard to some of their submissions saying the matter is no longer of concern. Is there anything in writing, or just a phone call, was it?
I think it was an email. To give you some context, their entire policy department resigned.
Yeah.
So that's probably more why there's...
It would be good to have for the record a copy of that email, please.
Yeah, sure.
Can I ask if you agree with the answer of Ms McLeod in relation to NFLP1 or places in this chapter where only reference to avoiding effects or mitigating effects are used rather than remedying? When I see remedy missing, is that deliberate in your assessment?
I guess in relation to the National Grid, yes. In saying that, it doesn't hurt because it's all of them, not, you can pick and choose. So I don't see any issue with adding remedy there, but I do agree with Ms McLeod that, the National Grid, it's pretty tricky to remedy the effects of that.
When you were responding to the idea of a definition for natural character, in your statement at paragraph 22, you were indicating that there's this natural default to the RPS definition. We don't need to suck the RPS definition into the PDP because that's automatically the next step up and where you would have to go to interpret things, which made sense to me. But in order to sort of explore things a little bit further, I guess, for the submitter, what are the other potential options for a natural character definition if we didn't just default?
I think we'd be taking strong guidance from the RPS anyway. So it would be very similar, if not identical, to that definition. Otherwise, yeah, the RMA doesn't necessarily help too much in terms of Section 6A. So I think in lieu of any other national direction, I would be recommending we default to the RPS definition. So I guess my comment still stands that in lieu of that, you're saying the same thing.
So in other words, it's neither here nor there whether the plan does what some of the definitions do, which is this means the same as this instrument. Yeah, which is something we could do.
We would, however, be reminded by way of legal submission that if we're going to refer to another document, there's constraints.
Is that another part of the answer, that the definition of natural character might shift? I've got a nod happening over there
Yes.
from your counsel. And that's another reason to be silent, you think?
Yeah, and then we can allow for things to update. The RPS will be going through a review at some point, and any update to that definition will presumably go through quite a thorough process. If we then, I wouldn't suggest if we were going to incorporate a definition that we would refer directly to the RPS, we just would copy the wording. But then if the RPS were to update, then that potentially becomes updated. So my recommendation is not to include a specific definition, and then when you're processing applications, you're considering the RPS, you're considering Appendix 6. I think that's a more practical solution.
At paragraph 24 of your statement, so I'm going against what I said before, I'm back in your statement. So I just wanted to check that I understood what you were saying here. So that we should understand that the setbacks are the trigger, so that's what they're doing. And once that's triggered, you require a natural character assessment, and that you anticipate that that assessment may identify natural character values that extend beyond the setback, or may vary in natural character within the setback, i.e. the setback line is just a trigger for an assessment to take place. It's making no judgment around an assumption of the level of natural character at that point, and then you have your natural character assessment, which might say, you know, that some particular values extend beyond the setback, or, you know, sort of minimal within the setback.
Yes, I would agree with that. Mike might want to weigh in terms of the extent of natural character surrounding those waterways.
I think the key point is where's the margin, is it not? Is that what you mean? Like the setback's a coarse way of
Yeah.
trying to say where the margin is. But
Okay.
the margin is subject to each site will be different in terms of where it is. So that's the limit that think would be the most relevant.
Just to add to that, I think practically it's more likely to go the other way rather than extend. It would be more likely to reduce and provide justification for those activities. Yeah, that would be what I would anticipate.
At your paragraph 36, where you're talking about these assessments, I did wonder, like you were pointing towards landscape architects as undertaking assessments. I think thinking about natural character, we might be talking about other kind of specialists as well, potentially ecological, but you know, we might not be restricted to landscape architects, but one way or another, what I'm interested in is the availability of the kind of expertise that will be needed to undertake these assessments, the availability of that expertise for people in the district wanting to, you know, move through the process.
Yeah, I wanted to be quite clear that it's not just a given that if you're 19 metres away from the Mataura River doing something that breaches those rules that you're going to need a full-blown landscape assessment. It's commiserate to the activity proposed, and I think realistically this wouldn't happen often. And in terms of the availability of suitably qualified landscape architects, I mean, Mike does a lot, and there's plenty in Queenstown to draw from. We've been processing consents in Southland for quite a long time, and that's never been an issue. Obviously, as soon as you're engaging other experts, that does add to the cost for a resource consent applicant. But as you said, the scale and significance of what you're doing is directly related to that. And just to reiterate what I said, that's not a new concept introduced through this chapter. That was already the case with the notified version of the plan.
At paragraph 45, you're talking about this idea of a standalone infrastructure chapter trying to do everything in one place. I wondered if you wanted to make some observations. What would you see as the risks in doing that? And or are there any? And if so, what might they be?
Okay, so I do agree that the national planning standards are not always helpful in this regard. They don't provide, they say that landscape matters need to be dealt with in the landscape chapter, infrastructure needs to be dealt with. There's a lot of cross-pollination. And so I do stand by my recommendation that the infrastructure chapter doesn't become a one-stop shop, mainly because I wouldn't want activities to be left out by accident and for things to be not to be managed. From my understanding, it's very unlikely that a layperson is going to be applying for these sort of activities. They're qualified professionals, and I just don't see an issue with opening more than one tab of the district plan. So I do agree that it could be located within the infrastructure chapter, but I wouldn't want to exclude the other district-wide matters from applying, more because of unintended leave-outs, I guess. and sorry, just to add on that, I'm currently involved with a big solar farm application in Naseby, and that plan does say the infrastructure chapter is a one-stop shop. We're still poring over the rest of the plan just to, put our best foot forward. So even then, I think you're not necessarily, I mean, yes, I don't technically need to do that, but from a community perspective, I think it is still suitable.
And Naseby.
Naseby, you said.
Naseby.
Yeah, and the operative plan says the utilities chapter is standalone, except in relation to Part 2 matters.
Yeah, so it's consistent with that approach.
So at your paragraph 49 of your statement, you were talking about Transpower's amendment to the definition of sensitive activities, and that you were open to considering an amendment. And yeah, so I'd noted something to revisit after hearing from Transpower, but I don't know that we've got anything to explore further there.
I guess I just wasn't quite sure why they wanted to introduce it. I assume it was more to do with that one-stop shop, so that if sensitive activities could sort of be expanded a little bit more with the policy framework in the natural character chapter. It does have that infrastructure policy, which will need to be amended to end up wherever we end up with the natural features and landscapes chapter. Yeah, so I'm open to considering that. I just needed a bit more of a reason why, and an evidential basis, which didn't really come up in Ms McLeod's evidence, but maybe will.
Well, yeah, because you do also know we might be looking at this again in hearing stream 10, so yeah. Okay, we'll keep our eye on it. That is me. That's all the questions I had for you from either document, actually. We've covered all of them before, so.
A couple of minor things. Proposed Rule 10 deals with woodlots, and so it's restricted discretionary activity in the lower sensitivity area. And one of the matters of discretion is the necessity of what is proposed and any alternatives. Now, how does that relate to woodlots? Because there's specific provisions elsewhere that deal with shelter belts. And so I struggled to think of why a consent needs to consider the need for growing trees.
I guess that's more to consider the location that you're growing those trees in. Do you need to be putting that woodlot within the ONL, or can you put it elsewhere? If the answer is our entire property is in the ONL, then that goes a long way to answering that matter of discretion.
To me, what you've just said isn't the way I would read that. And so if you want some consideration of why location, I think it needs specifically then to have location in there.
Yeah, that makes sense to me, what you said.
So if it read the necessity of the location full stop, and any other alternatives. In relation to quarries, and the answer may be it lies somewhere else, but why in Rule 7 is there no setback from rivers and streams? Talks about setbacks from boundaries, and elsewhere in the quarry rules, in rural, there's setbacks from rivers and streams.
I think those farm quarry rules in the rural zone would still apply.
May have a legal issue in terms of it's more specific here. So
Yeah, I see what you mean. Yeah, I have no issue with that being included. Stony Creek may want to weigh in. Yeah, in my view, they can sit beside each other, but I understand it's a little bit clunky.
Can I just ask, is it because of an answer that you gave earlier today, which is when you're looking at these things, say the farm quarrying activity, in relation to this rule, you're only thinking about landscape matters, so you've compartmentalised.
Yes.
Yeah. And so...
So setbacks from waterways are to manage a different effect.
Sorry, can't hear.
Setbacks from waterways are to manage a different effect outside of landscape. as well.
And that...
That's why I said elsewhere.
And
Yeah,
so
yeah.
that's where, are we presuming that will be picked up in the natural character provisions?
And or earthworks.
When you say natural
And
character, do you
earthworks.
mean within the zones
Yeah.
and
Because-
earthworks provisions?
Yeah, okay. Because we've got our natural character guidance, but it's being picked up in
The actual rules and
zones.
the underlying zones.
So the
yeah.
underlying zone, rural, which is why your answer,
Yeah.
that you're presuming that those rural zone rules will pick up effects that are not strictly landscape related.
Yes,
Great.
correct.
Excellent.
And that's probably a good point to pick up the other distinction we were talking about between eco rules and landscape rules, and the rule that cross-references. So if because that particular rule and the drafting and inclusion of that in this section is to manage landscape effects. So then you do have a cross-reference to eco, but eco is managing different effects.
Yes.
So take your point regarding managing internal references, but that doesn't remove the necessity for the direct consideration of landscape effects in these provisions, because you wouldn't then think about them in those terms if it was only in the other location.
Understood.
And we're very mindful of the need to avoid inconsistencies or conflict between the rules, particularly when it comes to Section 6 matters. It's not a matter of landscape or the ecological values, one dominating the other. The two should be able to mesh together without any conflict.
And they each have different relevant considerations. Yeah.
Yeah. If I may then go on to Rule 6, unless you want to keep talking about, yeah. So we'd talked earlier about whether it was necessary to specifically mention Clause 3 of Rule 6, which is the clearance complies with Eco Rule 1 and Eco Rule 2, because obviously the Eco chapter applies anyway. My concern with that is that, say, someone was to apply for a consent under Eco Rule 1 or 2, that be approved, they're not considering landscape effects. So due to that, I think it's suitable to keep this where it is, to make sure that those landscape aspects are considered. Yes, Keith.
But then potentially aren't you caught by Rule 2 that says that if you've got a permitted or consented activity, then it doesn't apply?
I guess what activity would you be consented under?
Well,
That wasn't this.
Yeah, so, and it comes up particularly in the ecosystems chapter, where reference is made to holding a consent for what? So, in clause 2, if it's for a permitted activity, there are many activities in the plan that are permitted, and if you're doing the clearance for any of the other activities in the plan that are permitted, then you're permitted to do the clearance here as well.
And the clearance complies with Eco Rule 1 and Rule 2. So you've got to be all those things and comply with Eco Rule 1 and Rule 2.
Okay.
That's getting really complicated, is my observation. And but I did want to weigh in because we've reached that sub-clause 2. So it is difficult wording. So my response to the theoretical example you just gave would be potentially it's not lawfully established because potentially it had breached this rule and had not obtained consent. So may not have been captured by the subclause 2.
I think the easy answer is that the Eco chapter needs to have a reference to this rule. And when we go to the electronic plan, which is the intent once this plan is operative, then that's going to be easily achieved. But in the meantime, we've got to ensure that that cross-referencing goes in.
Can I just ask if it's also to do with another answer that you gave earlier today, which was the critical ands. You know, it's 1 and 2 and 3, and that might also be an assist. I mean, it's helpful to have that other little kind of potential legal interpretation, but it does seem to me that just having something permitted or consented otherwise it isn't enough either, and so that was part of your answer for retaining that clause 3 as well. Yeah.
And I think advice notes are another mechanism that you could utilise if you were concerned that people were reading this rule in isolation. In terms of the reference to lawfully established, I have to confess that I don't have a very good memory and I can't recall the tenor of our conversation in Hearing Stream 1. But I thought it was more about existing use rights and references to existing use rights, which I have continued to say through the hearings. In my view, it's unnecessary to incorporate a reference to existing use rights in the plan. They're built in Section 10, so that's a replication of that. I'm not necessarily so sure that the function of this reference to legally or lawfully established, whichever words you might choose to use, is the same sort of, has been included for the same purpose. From my experience, where lawfully established activity is used in a rule like this, it's used in order to make sure that people don't rely on something they started doing which they weren't actually allowed to do in the first place. So say someone started up a business in an area where there was a consent required, then that would not be a lawfully established activity. So continuing on with an activity and them saying, well, that's my business and I've always done it there, it wasn't lawfully established in the first place. So that's, for me, what is captured there, distinct from the existing use point, which I may or may not have made in Hearing Stream 1.
And the reason why I've raised it is that over the last week I've actually gone back to all those earlier decisions as we head towards to check against the wash-up hearing. Are there things in there that need to be tidied up? And I'm still debating whether we're going to issue another list of things that we need to check off.
Perhaps we can turn to that at the end of this hearing, because that's where we're having a debate as well. So.
Have a clarification, please. I'm trying to figure out what all other areas means. Does it cover all zones? Does it cover the sensitive areas? What does that actually mean in the rules?
It's the ONL that isn't otherwise shown as being the lower sensitivity area.
So
Translated, it's the higher sensitivity area.
Yeah.
So that is the highest.
Which probably goes towards Keith's point of we could rename it. Yeah. It's the ONL broadly, just not the yellow bits are exempted.
Right, they're all the other areas.
Yeah.
Thank you.
Yeah, definitely not trying to apply this to the entire district.
No, that's what I was looking at, all other areas.
Sorry, could you repeat that for me, please?
So what Glenys is asking, I believe, is so where the rules sort of, let's say, Rule 1, it's broken up into lower sensitivity areas and then all other areas. So Glenys was just trying to clarify what all other areas means. It's the O and L, so it's the areas that you see behind you that aren't yellow.
Thank you.
I'm going to go to Mr Highstead in the back of the room and just ask Brett if there's anything that you want to contribute. It's all part of the one hearing. Glenys, thank you. In terms of, you heard my questions about setbacks from rivers and streams for quarries. What's the likely siting of quarries on the Stony Creek area? So the setback rule, depending on the size of the river as to how far back you need to be from the waterway. So for those little streams up on Stony Creek, it's a 5 metre rule. Probably will come up again in 2 weeks, but I'm just interested, where are the quarries on the property? And yeah, okay. All right, so panel, is there anything else you want to explore as part of this hearing today? Our advisors over there, is there anything else that needs to be raised today?
Just in relation to my tweaking of NFL Policy 3, what mechanism would you like that to be circulated or further workshopped?
Well, perhaps I can pick that up. We can propose to circulate it to the planners who have spoken to that policy today, and we can all provide you those comments by way of a hopefully one-page reply if that may be agreed to or may not. Would that be helpful?
Given we're up to minute number 39 or 40 about to be, that would be gratefully accepted. Thank you.
And so when you do that, can you come back just being really, really clear around what sits within the RMA definition of infrastructure, how that relates to our rural zone conversations around farm infrastructure and what's in that bucket, and what's sitting in critical infrastructure, and here's my hand, maybe look across to that minute 27 response around the different types of infrastructure under the different instruments relevant to this topic.
So we'll include it as a note of question from you.
Yeah.
Seeking information, potentially seeking feedback on those points.
Well, just so that that thinking is informing any redrafting, and just sort of show the connections between the redrafting and thinking about those different things, the 3 types of infrastructure and what the higher order instruments are saying. And particularly we've had some good evidence around what the RPS has to say, and not just the MPSs, depending on obviously that timing factor of the RPS age and the MPS age, but all of that I'd like to know is informing the final drafting together. Yeah.
So what I would anticipate you see is the original email seeking feedback, and then the feedback itself. So yeah.
And it will be longer than 1 page now. So that I guess.
No,
sorry.
You go.
Just is there a time frame on that response?
Well, it'll depend on other people. We'll be as quick as we can.
Yeah, because I'm not going to close the hearing today, I'm just going to adjourn it. That given that there's some crossover between this hearing and what's happening in the biodiversity issues, it may well be that there's a couple of things that come out of today that we want to address in a couple of weeks' time as well. So my intent then is just to adjourn for today for this hearing without giving a specific time frame, but hopefully within the 2-week period.
Certainly, so we can observe that we've got this further hearing, so it would be helpful to have that information before that. And turning to the wrap-up hearing, and it sounds like it is something that you've engaged with as a panel, the council consultants have also been wondering how to make sure that there's a public, not discussion, but a public process in terms of preparations for the wrap-up hearing. So one option would be for us to prepare a memorandum, perhaps proposing a list of issues. Another option is for you to issue a minute, but that may not capture, either way won't capture what both the panel and the consultants are thinking, while also enabling all parties to throw in their thoughts. So if you'd like to go ahead with the memorandum option, we can do that. You will probably then want to layer further stuff on top, and then we'll need to throw it out for comment for at least 3 weeks, I'd say, from other submitters. Did you have any directions or suggestions about what you'd like us to pick up there?
My expectation and hope was that you would volunteer to do a list first, and if necessary we will add to that. Whether that actually needs to go out for, the list needs to go out for feedback, I'm not certain. There is clearly a need for the list to be circulated to all submitters so they are aware of what is being covered. If my concern of putting it out to submitters is that they'll want to relitigate some of the points that we don't need covered in that.
I guess, and I totally accept that point, and I guess that would be for the panel to make a direction if you felt a party had raised an issue which didn't need to be relitigated. But I also am mindful that we don't know what we don't know, and there's gaps that as a council and as a panel we may not be able to see clearly. So while I take your point, my proposal would be that we put the memorandum out, we have a very short time frame for feedback from submitters, and then the panel issues a direction confirming that list with any additions subject to your consideration of the further feedback received.
So yeah, it's a slight variation of the way that I interpreted first up. What I'm hearing is that you'll prepare a memorandum that will get circulated to everyone. And then we will look at any feedback received plus add our own list to it and issue that. In terms of the issuing of Section 42A reports for the wrap-up hearing, they are probably due in about 3 weeks' time.
And that was part of the consideration for us filing a memorandum, was it may not be necessarily helpful for the usual 42A timeframe to be observed in this instance, because it would be inside the time we would have a hearing to go. So you then couldn't wrap up everything because there would still be one, I think it's natural hazards, whatever the last hearing is, would still be yet to go, and that might throw up, and in fact it does, it's natural hazards throws up internal inconsistency issues which need really to be captured for the wrap-up hearing.
Part of your memorandum suggests a modified timetable, notwithstanding that as a panel we're reluctant to play around with that timetable other than from process.
The expectation is that it's refined, so it's not as dense as something like NFL, eco, natural hazards. That would be the aspiration, perhaps.
So if we're done on those issues as well, then we shall adjourn for today. Thank you for people being present. To Coral and Brett at the back, thank you for being here. Your contribution from the two of you has been well received and appreciated. To the staff, to Mike, seeing on deck here for I think the first time in the hearings, thank you for being here today. And to our legal advisors, as always, we appreciate your advice. So thank you one and all, and to our Min people, we'll adjourn. Cheers.